Kenneth Dwayne Williams. In October of 1999, a man serving a life sentence inside one of Arkansas's most secure prisons hid himself in a barrel of hog waste and let a truck haul him straight out through the gate. He had been behind those walls for barely 19 days. Before he was caught again, 2 more people were gone, and a chase across the state line had cost the life of a 4th. Kenneth Dwayne Williams was born in Pine Bluff in February of 1979. He grew up in a home marked by drugs and violence, and by his own account, he was pulled into gang life young. Before any of this, in 1996, he had already served a 5-year sentence for battery and for a first-degree escape. That earlier record showed a man who did not intend to stay wherever the state put him. Even so, nothing in it pointed to the scale of what he would do across a single week in December of 1998. It began in a restaurant parking lot in Pine Bluff. Williams forced a 19-year-old pre-med student and cheerleader named Dominique Hurd, along with a companion, Peter Robertson, into a vehicle at gunpoint. He robbed them, made them withdraw cash from an ATM, and then opened fire on both. Dominique Hurd did not survive. Peter Robertson did. That same day, Williams took the life of a 36-year-old man named Gerald Jenkins. Years later, from a prison cell, he would confess to that second shooting in a letter to a local newspaper, a death the state had not even pinned on him at the time. He was convicted of capital murder for Dominique Hurd's death and sentenced to life without parole. 19 days into that sentence, he was gone. Hidden inside a container of hog slop being hauled off the prison farm, he slipped past the walls of the Cummins Unit and into the surrounding countryside. Nearby, he came across a 57-year-old former deputy prison warden named Cecil Boren, who was out working his own land. Williams took Boren's life and stole his truck. He drove north into Missouri, where a high-speed police pursuit ended in a crash. That wreck took the life of Michael Greenwood, a 24-year-old man from Springfield who had nothing to do with any of it. Williams was pulled from the scene and taken back into custody, and this time there would be no barrel of slop, no shift change, no way out. The manhunt was over, but the accounting of what he had done in 19 days of freedom was only beginning. How does a man convicted of taking 1 life end up responsible for 3 more within 3 weeks of arriving in prison? The answer the courts arrived at was capital murder, a second time. In 2005, Williams was convicted for the death of Cecil Boren and sentenced to death, and the Arkansas Supreme Court affirmed it. His appeals then moved through the federal system for years. In July of 2010, the Eighth Circuit rejected his claims that his trial lawyers had failed him and that his rights had been violated. His last real argument was that he was intellectually disabled, a claim that, if proven, would have barred his execution under the Supreme Court's ruling in Atkins versus Virginia. On the night he was scheduled to die, the Supreme Court denied his request for a stay and declined to take the case, with no recorded dissents. His execution came at the end of a schedule that had drawn national attention. The governor had set 8 executions across 11 days in April of 2017, racing against the expiration of the state's supply of one of its lethal drugs. 4 of the 8 were halted by the courts. 4 went forward, and Williams was the last of them. What happened in the chamber that night became a matter of dispute. An Associated Press editor named Kelly Kissel, who was witnessing his 10th execution, reported that Williams's body jerked 15 times in quick succession, lurching against the strap across his chest, and that it was the most he had ever seen a condemned inmate move that far into the process. Williams's attorney called the accounts horrifying and said the witness reports indicated his client had suffered. The governor's office rejected that reading. A spokesman described the movements as an involuntary muscular reaction, a known effect of one of the drugs in the protocol, and the governor dismissed calls for any investigation. There was one more turn to it. The family of Michael Greenwood, the young man who died in the crash during the escape, publicly forgave Williams. So did the mother of Dominique Hurd. In the years since, that forgiveness has become as much a part of the case as the violence that started it. As of today, Kenneth Williams is deceased, put to death at the age of 38. His case remains one of the most cited from Arkansas's disputed 2017 execution schedule. His guilt was never in real doubt. What people still argue about is what the witnesses described seeing in the chamber that night. The state insisted Williams felt nothing more than a drug reaction in his final minutes. The man who died on that same gurney years earlier raised a harder question, because he may not have understood he was dying at all. Ricky Ray Rector. On the night he was to be executed in 1992, Ricky Ray Rector ate most of his last meal, but set the slice of pecan pie to one side. He told the guards he was saving it for later. He did not seem to understand that there would be no later. And the reason he did not understand would pull a sitting governor off the presidential campaign trail and into the middle of a national argument. Rector was born in Conway in January of 1952. In March of 1981, after being turned away from a private party at a Conway restaurant, he came back with a gun, fired into the room, and took the life of a man named Arthur Criswell while wounding 2 others. Then he ran. Over the next 2 days, police negotiated with him through his family, and he agreed to surrender to a specific officer he trusted. When that officer, Robert Martin of the Conway Police, arrived at his mother's home to bring him in, Rector took his life instead. Then he turned the gun on himself and fired a bullet into his own head. He survived. But the surgery to remove that bullet took a large section of his brain with it. What remained was a man with severe, permanent damage, the practical equivalent of a lobotomy. The person who would eventually stand trial was not, in any meaningful sense, the same person who had pulled the trigger. He no longer grasped the basic facts of his own situation, and there was medical agreement that the damage was real and irreversible. If a man cannot comprehend that he is going to die, what is his execution meant to accomplish? He was tried separately for the 2 deaths. For Arthur Criswell, he received a life sentence. For the death of Officer Martin, he was sentenced to death in November of 1982. What followed was more than a decade of litigation over a single unsettled question, whether a state may put to death a man who does not understand that he is about to die. The Supreme Court had already ruled in Ford v. Wainwright that the Constitution forbids executing a person who is insane, and Arkansas had its own statute on the matter. But competency, as the law defined it, was a narrow test. The state evaluated Rector 3 separate times, and each time examiners concluded he was competent enough to be executed. In 1991, the Supreme Court declined to intervene over the dissent of Justice Thurgood Marshall. Clemency was denied the following January. By then, the case had drawn reporters from across the country, and the questions it raised about competency and punishment were being argued well beyond the borders of Arkansas. That question landed in the middle of a presidential race. In January of 1992, the governor of Arkansas, Bill Clinton, left the campaign trail just days before the New Hampshire primary and returned to the state to preside over Rector's execution. To his critics, it looked like a candidate determined to appear tough on crime at a moment when the whole country was watching. To Rector's supporters, it looked like the execution of a man who could not follow his own sentence or understand what was about to be done to him. Both readings hardened into the version of the story people would repeat for decades. The execution itself was drawn out and difficult. The team worked for more than 50 minutes trying to find a usable vein, and witnesses said Rector could be heard moaning as the search dragged on, counting some 8 sounds of pain before the drugs were finally delivered. Behind a partition, he had reportedly been helping the medical staff look, unaware of what the search was for. When it was over, the argument it had started did not end with him. What made the case so hard to look away from was how visible the damage was. Rector functioned, by many accounts, at the level of a young child. He paced the same short path in his cell for hours at a time. He could not link his crimes, his trial, and the execution date into a single chain of cause and effect. When he set his dessert aside to finish later, the lawyers fighting his sentence pointed to it as plain proof that he did not understand what the night held. Rector's case became a permanent fixture in the debate over the death penalty and mental competency. The year after his death, Arkansas adopted a mitigating circumstance for intellectual disability, and in 2002, the Supreme Court in Atkins v. Virginia barred the execution of the intellectually disabled outright, the very protection Rector never had. As of today, Ricky Ray Rector is deceased, put to death at the age of 40. In death penalty scholarship, his name has become shorthand for the hardest version of the competency question, the case people reach for when they want to ask how far the state should be allowed to go. He is remembered less for what he did than for the question his death left open. Rector never grasped how the system was going to end his life. The 2 men who come next knew the workings of Cummins intimately, and they used that knowledge to walk straight out the front gate. Jeffrey Grinder and Calvin Adams. On a Friday evening in the spring of 2009, 2 convicted men walked out the front of a maximum security Arkansas prison in guard uniforms they had stitched together inside its own walls. A car was waiting for them. No alarm sounded. It would be more than 3 hours before anyone realized their cells were empty. Neither man was on death row. Jeffrey Grinder and Calvin Adams were serving life without the possibility of parole for separate, unrelated crimes, and the only thing that ever tied their names together was the night they decided to leave. But that night made them 2 of the most talked-about inmates the Cummins Unit ever held, because they exposed how thin the line between inside and outside really was. Calvin Adams had been convicted in Greene County in 1995. The year before, he had taken a 25-year-old man named Richard Austin and Austin's wife, Cassandra, from their home, part of a plan to rob a bank Austin worked near, the Leachville State Bank. When Adams learned that Austin could not actually get him into the vault, the plan fell apart. But he did not let the couple go. He drove them to a remote levee and shot them both, then returned and set their car on fire to destroy the evidence. Richard Austin's life was taken there. Cassandra survived a gunshot to the chest and a fractured skull, and she walked nearly a mile to find help. Jeffrey Grinder's road to Cummins is harder to trace. He was convicted of capital murder in 2004 and sentenced to life without parole, reportedly out of Washington County. Beyond that, the public record thins out. Unlike almost every other name on this list, the details of his crime, the victim, the date, the circumstances, are not laid out in any appellate record, which strongly suggests he pleaded guilty rather than standing trial. What is documented, and documented thoroughly, is the escape. On the evening of May 29, 2009, after the 6 o'clock head count, the 2 men changed into inmate-made uniforms in the prison library and walked out during a shift change, straight into a maroon sedan someone had left waiting for them. They were not missed until the 10 o'clock count, which handed them a lead of more than 3 hours. The plan reached well beyond the 2 of them. 3 people on the outside, 2 from Little Rock and one from Jacksonville, had helped arrange it, and all three were later charged with furnishing implements for the escape. Sightings placed the pair first in southeast Missouri, in small towns like Haiti and Braggadocio, then farther north into Michigan. Investigators came to believe they were heading for the Canadian border, far from the cells they had left behind. How do two men convicted of capital murder simply walk out the front gate of a maximum security prison? The answer turned out to be a mix of homemade uniforms, a crew on the outside, and a chain of failures within the institution. On June 2, 2009, 4 days after they vanished, a state trooper near Hornell, New York, tried to stop their car for speeding. It crashed, and both men ran on foot before they were finally caught. Grinder and Adams each pleaded guilty to the escape itself and received 6 additional years, added to sentences that already had no end. 3 people on the outside who had helped coordinate the breakout were charged as well, accused of furnishing the means to get away. Inside Cummins, the fallout was sweeping. 6 guards were fired, another was disciplined, and the prison ended the single practice that had made the whole thing possible. It stopped letting inmates sew guard uniforms. The escape became a national embarrassment for the state, the kind of story that gets picked apart in reviews and hearings for months. 2 men convicted of taking lives had defeated a maximum security prison using needle, thread, and patience, sewing their disguises in plain sight during their assigned work details. The policy changes that followed were the state conceding, in its own way, that it had handed inmates the means to walk out. For Calvin Adams, even that was not the end of it. About a decade on, in the fall of 2019, he got out again. This time from the East Arkansas Regional Unit in Brickeys. That attempt did not last long. Officers found him hiding under a ventilation hood on the prison roof. He had not gotten far, but he had once again gotten out of his cell and up onto the roof of a second Arkansas prison, 10 years after the first time. As of today, both men remain incarcerated, still serving life without parole. Neither was ever sentenced to death. Their place on any list of the most dangerous men Cummins held rests not on a death sentence, but on a plainer and more unsettling fact. A maximum security prison could not reliably keep them inside. Escaping Cummins is one way to leave a mark on the place. The man who comes next never tried to leave. He spent more than 2 decades there while the courts argued over whether the state was even allowed to put him to death. Charles Laverne Singleton. For more than 20 years, Charles Singleton sat on Arkansas's death row while the courts wrestled with a paradox no one had cleanly solved. Singleton was too mentally ill to be executed, but he had a condition that medication could control. So the state faced a question with no comfortable answer: whether it could force those drugs into him, restore him to sanity, and then put him to death, all in the name of the law. The crime that brought him there happened in June of 1979 in the small town of Hamburg. Singleton, who was 20 at the time, attacked Mary Lou York, the owner of a grocery store, stabbing her in the neck. She was rushed to the hospital, where she died of blood loss. The case against him was unusually strong. Before she died, York named Singleton to the first officer who reached her, and again to her own physician, a dying declaration that carried real weight in court. 2 other people, one of them a relative of Singleton's, placed him at the scene and identified him as the man responsible. There was little genuine dispute at trial about what he had done. The dispute that would define his case, and eventually the law itself, was still years away, and it had nothing to do with his guilt. He was convicted in 1979 of capital felony murder and of aggravated robbery, and sentenced to death. On appeal, The robbery conviction was set aside on double jeopardy grounds, but the capital murder conviction held, and the Arkansas Supreme Court affirmed it in 1981. At that point, his case looked like many others on the row. Then his mind began to come apart. Within a few years of his conviction, Singleton was diagnosed with schizophrenia. By the late 1980s, he was seriously ill, moving in and out of delusion, at times convinced of things that were not real and unable to be reached by the people around him. Under the Supreme Court's precedent, a person who is insane cannot be executed because a punishment carried out on someone who cannot understand it serves no lawful purpose. But Singleton's symptoms eased when he took antipsychotic medication. That is precisely what turned his case into a landmark. Medicated, he was considered sane enough to be executed. Unmedicated, he was not. The unresolved question was whether the state could compel the medication for the specific purpose of clearing the way to his death. The courts had a framework for forced medication when it served a prisoner's own medical interest, but no one had squarely faced what it meant when the interest being served was arguably the state's interest in a working execution. Is a man being healed when he is medicated only so that he can be put to death? The case, known as Singleton versus Norris, went to the Eighth Circuit Court of Appeals. In 2003, sitting as a full court, the judges ruled that the state could forcibly medicate him so long as the treatment was genuinely in his medical interest under existing standards. The court reasoned that the medication truly benefited him and that his execution was a separate matter from his care. The Supreme Court declined to review the decision, and with that, the ruling became settled law. The decision left a mark well beyond Singleton himself. Medical bodies had long held that a physician's duty is to heal, never to prepare a patient for death, and Singleton's case forced that principle into direct conflict with the machinery of a capital sentence. It has been examined in the American Medical Association's own Journal of Ethics and taught in law schools as one of the clearest examples of the problem, precisely because there was no comfortable answer. A prison psychiatrist treating Singleton could ease his suffering, and in doing so, deliver him to the execution he could not otherwise have faced. Doing nothing left a man trapped in his own delusions. Over the course of his time on death row, Singleton's execution had been scheduled and reset 5 separate times as the litigation moved. He was executed by lethal injection at the Cummins Unit in January of 2004. He had been on Arkansas's death row longer than any other inmate at the time, roughly 24 years, and he was the last person in the state offered a choice between the electric chair and lethal injection. He chose injection. In his final years, he had been taking his medication on his own, and by his own request, the fight to spare him had ended. His case did not fade when he did. It remains a fixture in the study of medical ethics, cited in arguments over whether doctors should ever take part in restoring a prisoner to health so that a state can end his life. As of today, Charles Singleton is deceased, put to death at the age of 44. The precedent his case set, that a state may medicate a condemned inmate into competency in order to carry out his sentence, still stands. Singleton's story turned on how far a state would go to end a life. The last man in this stretch never faced an execution at all. His life ended inside Cummins in a way no sentence had planned for. Robert Todd Birmingham. For nearly 2 years in the late 1990s, women driving alone through the Arkansas Delta grew afraid to pull over, even when the lights behind them looked like the police. One man had discovered that a flashing blue light mounted on a dashboard was all it took to make a stranger stop her car on a dark highway. The search for him would become one of the largest investigations in the history of the Arkansas State Police. Starting in 1997, The man behind that light targeted lone female motorists along the highways of the Delta. He would fall in behind a woman driving by herself, switch on the blue light, and pull her over as though he were an officer making a routine stop. Once she stopped, he abducted her. He was believed to be responsible for a string of attacks on as many as 4 women, and he would later be convicted in connection with more than one of them. Because of the method, the public and the press came to know the whole case by the blue light at the center of it. The fear spread far past his actual victims. Across Arkansas, drivers grew so wary of unmarked flashing lights that some stopped pulling over for legitimate stops at all, which put ordinary officers in a strange and dangerous position on the roads. A single man had managed to poison the basic trust between the public and the badge across an entire region. The response was enormous. Nearly 50 state troopers were assigned to the case, part of a multi-agency effort that stretched across the Delta for roughly 2 years. It was one of the largest manhunts the state police had ever mounted, and for much of it, they had no name to attach to the light. Every stop, every account, every scrap of description was measured against a pattern that kept repeating on the dark stretches of Delta Highway. The break came through science. Investigators had been working the Delta for close to 2 years, following tips, comparing accounts, and trying to turn a method into a suspect. In the end, it was DNA that closed the gap. 2 attacks in Cross County produced genetic evidence, and that evidence pointed to one man. He was arrested at a farm shop near his home in St. Francis County. The man behind the blue light finally had a name: Robert Todd Birmingham. How does one man hold an entire region hostage using nothing more than a light that anyone could buy? The legal reckoning came in stages. His first case went to trial in 1997 and brought a sentence of 80 years. The following year, in Cross County, he was convicted of aggravated robbery, kidnapping, and the serious felony offenses tied to the blue light attacks, and this time he was sentenced to life. He maintained his innocence throughout both proceedings, even after the DNA evidence tied him to the attacks. He was suspected in still more cases for which he was never brought to trial, leaving a question over exactly how many women had been stopped by that light on a lonely road. It is worth being precise here, because it sets him apart from most of this list. Birmingham was never a murderer, and he never faced a death sentence. He was a life inmate, held at Cummins alongside the condemned, but the harm he did was of a different kind. Out of the case came a lasting change to Arkansas law. One of the survivors, Shannon Woods, helped push through what became known as Shannon's Law, which made it a crime for civilians to possess or use blue lights or law enforcement insignia, the very tools that had made the attacks possible in the first place. Her name is now attached to the statute that closed the loophole he had exploited. Birmingham's life ended not by any sentence, but by disease. In the spring of 2020, the Cummins Unit became the center of one of the worst prison outbreaks in the country during the early months of the pandemic. The numbers were staggering for a single facility. By the 28th of April that year, 860 inmates at Cummins, nearly half of the entire population of the unit, had tested positive for the virus. Birmingham was one of them. In May of 2020, he died at a Little Rock Medical Center of respiratory failure and viral pneumonia brought on by COVID-19. As of today, Robert Todd Birmingham is deceased at the age of 54, having died in custody while serving his life sentence. Shannon's Law is still on the books in Arkansas. For Birmingham, science was what finally closed the case, giving the man behind the blue light a name and ending years of fear on the Delta highways. The next man on this list was convicted in the same era, before modern testing was anything close to routine, And in his case, that same science would return years after his execution, to raise a question the state has never been able to put to rest. If you're liking this video and you're not subscribed yet, now's the time. We drop new cases every day. Subscribe so you don't miss the next one. Liddell Lee. In the spring of 2017, Arkansas ended a pause of nearly 12 years in its death chamber, and Liddell Lee was the first man it put to death. He went to the gurney saying what he had said for more than 2 decades, that he was an innocent man. 4 years later, a piece of evidence that no one had ever tested would suggest he might have been telling the truth all along. Deborah Reese was 26 years old, a young woman living in Jacksonville, Arkansas, and by the accounts of those who knew her, entirely ordinary in the best sense of the word. On the 9th of February, 1993, she was attacked inside her own home, and her life was taken. The weapon was a small wooden club, a tire tool that her husband had given her for protection against exactly the kind of harm that found her. Roughly $300 was missing from the house. The case against Lee came together quickly. He had been released on parole only about 10 weeks earlier, after serving time for burglary and theft, and he was already tied to a series of other attacks on women in the same part of the county. Neighbors reported seeing him near Reese's home around the time of her death. He was arrested less than an hour later, after spending some of the money that had been taken. To the police and the prosecutors, the picture looked complete, and a jury agreed. But Lee never wavered. From the day of his arrest, through every year that followed, he insisted he had not done it. How certain can a verdict really be when the man it condemns never once stops saying it is wrong? He was convicted of capital murder and sentenced to death in October of 1995 in Pulaski County. The Arkansas Supreme Court affirmed the conviction in 1997, and his case then settled into the long machinery of appeals. His later lawyers argued that his original trial counsel had been impaired and ineffective, that the lawyer who defended his life had not been in a fit state to do it. They pointed out that no physical evidence had ever directly placed his hand on the weapon, and that the case rested heavily on witnesses who had placed him near the scene. More than once, they asked for the biological evidence from the home to be tested with methods that had not existed at the time of the trial. Those requests were denied, in part because a judge concluded that the eyewitness accounts made testing beside the point. Then came April of 2017, and the schedule that would define this whole period in Arkansas. The state had lined up 8 executions across 11 days, an unprecedented pace driven by the coming expiration of one of its lethal injection drugs. 4 of those executions were stopped by the courts. 4 went forward, and Liddell Lee was the first of them. On the night of April the 20th, his lawyers filed a last round of stays, and the 8th Circuit rejected each one. He was taken to the death chamber within minutes of the Supreme Court clearing the way, in a procedure that took roughly a quarter of an hour, the first person Arkansas had executed since 2005. In his final interview, given to a foreign broadcaster, he said again that his dying words would be the same as they had always been, that he was an innocent man. The story did not end there. In January of 2020, lawyers with the Innocence Project and the American Civil Liberties Union, acting on behalf of Lee's sister, sued to force the release of fingerprints and biological evidence from the crime scene, material that had never been run through a modern database. When the testing was finally done and the results released in the spring of 2021, they showed something the trial had never accounted for. Deoxyribonucleic acid belonging to an unknown man was found on the handle of the murder weapon and on a blood-stained shirt at the scene. Of 6 hairs tested, 5 could not have come from Lee. No match to that unknown profile has ever been found in any database. A pathologist noted that whoever committed such a close, violent attack would almost certainly have carried the victim's blood away on his body, and yet the traces on Lee's own belongings were inconclusive at best. The state did not concede an inch. The Attorney General maintained that Lee had been lawfully convicted and that the new findings were inconclusive, and the governor who had signed the death warrant said the results did nothing to undermine the courts that had reviewed the case for decades. To his family, and to the organizations that fought for the testing, the numbers said something else entirely. As of today, Liddell Lee is deceased, put to death at the age of 51. Whether the state executed the right man is a question his conviction once seemed to answer, and that a set of test results, arriving 4 years too late, pried back open. Lee's guilt is something people still argue over. The next man on this list left no room for that argument at all: Jack Harold Jones. He gave a long, final statement before he died, and near the end of it, he said he hoped that, in time, people might come to see who he really was, that he was not a monster. Jack Harold Jones had admitted, years earlier, to what he had done. What made his case echo far beyond his own guilt was the night it belonged to. A night that put the machinery of the death chamber itself on trial. The crime that sent him to death row happened in June of 1995 in the small town of Bald Knob. Mary Phillips was 34 years old, a bookkeeper who worked in an accounting office, and it was there that Jones came upon her. He told her he intended to rob the place, and then he took her life. A child who had come to the office with her that day was also harmed but survived, and would later become one of the most important witnesses against him. That detail, the presence of a young survivor, gave the case a weight that most never carry. It was that witness who helped tie Jones to the scene, describing him and his markings to investigators in detail that left little doubt, and who later faced him from the stand at trial. Prosecutors would point to that testimony for years as the spine of the case against him. Jones had also, years before, been convicted of a strikingly similar crime in Florida, a history that framed the Arkansas case not as a single act, but as a pattern he carried with him from one state to another. What does it change, if anything, when the condemned man does not deny the thing he is about to die for? Jones was convicted of capital murder and sentenced to death in 1996. He spent roughly 22 years on death row while his appeals moved through the courts. His lawyers argued that his original trial attorneys had failed to put before the jury the full record of his mental health struggles, evidence they believed might have persuaded jurors to spare his life. Those arguments did not succeed. When he came up for a clemency hearing in April of 2017, his own attorney told the board that Jones had requested it largely in solidarity with the other men facing execution that month, rather than out of any real expectation of mercy. Like Liddell Lee, he had become part of the compressed April schedule, one of the men the state meant to execute before its drug supply expired, and on the day itself, the Supreme Court declined to halt his execution. By then, the courts had reviewed his conviction and sentence for more than 2 decades, and every avenue his lawyers had opened had closed again. The schedule, not any new finding in his case, was what finally set the date. His execution, on April 24th, is where that schedule drew its harshest scrutiny. Jones was in poor health, a longtime diabetic who had already lost a leg to the disease and who used a strong daily pain medication, and his lawyers had warned that his condition could keep the sedative from working as intended. In the chamber, the team assigned to place the intravenous line struggled with it for more than 45 minutes, eventually working at a central line in his neck. The drugs were finally administered a little after 7 in the evening, and he was pronounced dead 14 minutes later. According to a court filing made that same night, witnesses saw Jones moving his lips and gulping for air during the procedure, which his lawyers argued meant the sedative had failed and that he remained aware as the other drugs took hold. The state rejected that account and insisted the execution had been carried out properly. But the filing was not written for the history books. It was written in real time, because there was another man scheduled to die on that same gurney only hours later, and his lawyers wanted the court to see what had just happened. The reason two men were set to die on the same evening at all traces back to the whole design of that April. Arkansas had not carried out a double execution in nearly 2 decades, and no state in the country had done so since the year 2000. The compressed calendar existed for one reason: the looming expiration of the sedative at the heart of the state's lethal injection formula, a drug that had been linked to troubled executions elsewhere, and that sat at the center of nearly every legal challenge these men raised. Jones's fate and the fate of the man who followed him were bound together by that single deadline, and the questions his execution raised did not stay with him. They passed directly to the next name on the schedule. As of today, Jack Harold Jones is deceased, put to death at the age of 52. His final words were an apology to the survivor of his crime and a plea to be remembered as something more than the worst thing he had done. Jones met exactly the end the state had planned for him. The next man on this list reached his own ending in a way no sentence had ever ordered: Troy Allen Crook. Not every man who frightened the people around him ended his days in the execution chamber. Some the state condemned but never got to, and at least one of them died inside Cummins in a way that no court had ever written into a sentence, by his own hand, alone in a cell, years after the crime that put him there. Troy Allen Crook was a Jacksonville man whose life had been marked by instability long before the crime that defined it. By the time he reached his late teens, he had been committed to psychiatric facilities on numerous occasions and diagnosed with bipolar disorder. As a child, he had been involved in a shooting that took the life of a childhood friend, an event the courts treated as accidental. The thread of a troubled and largely untreated mind ran through his story from the very beginning to its end. The crime that sent him to prison for the rest of his life took place in Faulkner County. Crook and another man, Ronald Dean Charles, took the lives of two cousins from Valonia, Bobby Brock, who was 45, and Lonnie Brock, who was 62. Prosecutors said the pair had been searching for money to buy drugs, and that the deaths grew out of a robbery that turned lethal. Both cousins were attacked, and neither survived. How does a man diagnosed and hospitalized again and again still arrive here, with 2 lives taken and a cell waiting? The legal path his case took set him apart from most of the men around him. As his prosecution moved forward, there were serious questions about his mental state and his competency, and the friction spilled into open court. In one hearing, Crook tried to dismiss his own public defender and declared that he would represent himself, growing agitated enough that the exchange nearly stopped the proceedings. State doctors had found him competent to stand trial, a finding his defense wanted to challenge. In the end, rather than face a capital trial and the real possibility of a death sentence, Crook and his accomplice pleaded guilty. Crook accepted a term of 100 years in prison, which for a man his age amounted to a life sentence under another name. He entered the custody of the Arkansas Department of Correction in October of 2009 and was eventually held at the Cummins Unit. There was no long appellate saga of the kind that trailed the men on death row, no decades of stays and petitions. His guilty plea closed the legal chapter almost as soon as it opened. What did not close was whatever had followed him for most of his life. In May of 2019, Staff at Cummins found Crook in his cell with self-inflicted injuries. He was taken first to the prison infirmary and then to a hospital, where he died the following day. He had been housed alone at the time, and the Arkansas State Police opened an investigation into his death, as the state does whenever a person dies in its custody, alongside an internal review by the prison itself. There would be no trial to follow, no appeal, no clemency petition. The man who had once faced the possibility of a death sentence and avoided it by pleading guilty had reached the end of his 100-year term a decade into serving it. His case is a quieter one than most on this list. There was no execution date, no last meal, no witnesses gathered behind glass. But it belongs here because it captures something true about a place like Cummins. The unit did not only hold the men the state intended to put to death. It also held men whose most dangerous acts were long finished before they ever arrived, and who carried whatever had driven those acts with them until there was nothing left to carry. It is worth remembering that the harm in his case did not end with him. 2 men were gone, a family in Valonia was left without them, and Crook's accomplice faced his own reckoning in the courts for the same night's work. And the pattern that ran through Crook's life, the repeated hospitalizations, the diagnoses, the long stretches where a clearly unwell man moved through the system without ever being reached, is one that follows a certain kind of inmate into a place like Cummins and does not leave. He was dangerous, and he was also, by every record of his life, profoundly ill, and the prison held both of those truths at once until the day he died inside it. As of today, Troy Allen Crook is deceased, having died at the age of 40 inside the Cummins Unit from self-inflicted injuries, a term of 100 years left unfinished, with most of it still ahead of him. For the men on death row, the state fixed the hour and the method and the witnesses in advance, and fought in court for years over every detail of how it would be done. Crook's ending came with none of that apparatus, no warrant, no clemency board, no drug protocol argued before a federal judge. And yet the result was the same in the only way that finally matters. A man went into the Cummins Unit and did not come out. Crook's death was one the state never scheduled. To find its opposite, you only have to return to that same tense April, and to the man who died on the very same night as Jack Jones, Marcel Wayne Williams. On the night Jack Jones was executed, a second man sat waiting in the same prison, and his lawyers were about to use what had just happened to Jones as their final argument to save him. Marcel Wayne Williams had spent 2 decades on death row for a crime he never disputed. What remained in dispute in his last hours was whether the state could end his life without inflicting the very suffering the law was meant to prevent. Stacy Erickson was 22 years old, a nurse technician, and a mother of 2 young children. On a November morning in 1994, she stopped for gas at a station in Jacksonville on her way to work. There, at gunpoint, Williams forced his way into her car and took her from that ordinary moment into the last hours of her life. He made her withdraw money from a long series of automated tellers, close to 18 of them, the transactions caught on one security camera after another, until a few $100s had been drained from her account. Then he took her life. Her belongings were later found at a storage facility, and her body was recovered from a shallow grave in a North Little Rock Park about 2 weeks after she vanished. Williams was arrested days afterward in connection with other attacks, and he confessed. The evidence was overwhelming, reinforced by that trail of camera footage that documented the hours of Stacy Erickson's abduction almost minute by minute. At trial, the jury needed only about half an hour to reach its verdict. There was never any genuine question that he had done it. Can the way a man is put to death matter, even when what he did to arrive there was beyond any doubt? He was convicted of capital murder and sentenced to death in January of 1997, and he received additional life sentences and decades more in prison for separate attacks on 2 other women. For roughly 20 years, his appeals worked through the courts. The centerpiece of his case was a claim that his original lawyers had failed him, that they had never laid before the jury the full and harrowing record of his childhood, a childhood shaped by severe abuse and neglect that his later attorneys argued might have moved jurors toward a sentence short of death. He himself acknowledged his guilt to the parole board and said plainly that he wished he could undo it. In the days before his arrest, he had attacked 2 other women, and it was those crimes that first brought him into custody before he confessed to what had happened to Stacey Erickson. That history made the mitigation argument a hard one to win. The courts, in the end, allowed the death sentence to stand, and on the day itself, the Supreme Court declined to intervene. Then came the night of April 24, 2017. Williams was scheduled to die within hours of Jack Jones, part of the same compressed timetable. When Jones's execution appeared, to witnesses to go wrong, Williams's lawyers rushed an emergency filing to a federal judge, arguing that what had just been seen in that chamber showed their client faced a real risk of an agonizing death, a risk made worse by his own poor health and considerable weight. The federal judge who received the filing, Christine Baker, briefly halted the execution while she weighed it, then lifted her own stay roughly an hour later, and the state was cleared to proceed. Williams was taken into the chamber and put to death, the procedure beginning late in the evening and ending when he was pronounced dead at 33 minutes past 10. He declined to offer any final words. The governor, afterward, framed the outcome as justice finally arriving for the Erickson family after more than 20 years of waiting, while the men who had fought against that April's schedule saw in the same night confirmation of everything they had feared about the pace and the method. For years, the courts examined whether the failure to present his childhood to the jury should cost the state his death sentence. It is a recurring question in capital law, how much weight a jury should have been allowed to give to the forces that shape a person long before they ever commit a crime, and whether a lawyer's failure to gather that history amounts to a failure of the trial itself. In Williams's case, the answer the court settled on was that the conviction and sentence would hold. His guilt had never been the issue. The issue was everything the jury had not heard, and everything about the night he finally died. As of today, Marcel Wayne Williams is deceased, put to death at the age of 46. His case sits at the center of the argument over that April in Arkansas. No one doubted his guilt. What his death raised, along with the death that preceded it by 3 hours, were hard questions about how the state carried its sentences out. The frantic pace of that April was only possible because the chamber had sat idle for so long before it. To understand what the state was restarting, you have to go back to the last time it had been used at all. Eric Randall Nance. For nearly 12 years, Arkansas did not execute anyone. The machinery sat quiet and the chamber unused until the rush of 2017 brought it roaring back. The last man to die in it before that long silence was Eric Randall Nance, and his final minutes were interrupted by a phone call from the highest court in the country. Julie Heath was 18 years old, a cheerleader from Malvern, Arkansas, remembered by those who knew her as a bright presence in a small town. On an October evening in 1993, her car broke down along a stretch of United States Highway 270 as she was driving to see her boyfriend. Eric Nance came upon her there. By the account the state would later prove to a jury, he offered her help and instead took her life, using a box cutter. Her car was found abandoned on the highway, and her body was found by a hunter about a week later, several miles away. Nance was not a stranger to violence when he crossed paths with Julie Heath. Only months earlier, he had been released from a lengthy Oklahoma prison sentence, one he had served for a violent assault years before. He had been free for a matter of months when Julie's car broke down on that highway, a fact that would sit heavily over the case. The sense that the danger he posed had been known and documented, and then simply returned to the road. In the days after Julie vanished, he began telling people he was afraid someone would invent a story connecting him to her disappearance, an unease that drew attention rather than deflecting it. He was arrested within days of her body being found. In the small towns of Hot Spring County, the search had been all-consuming. Officers stopped car after car along that highway in the hours and days after Julie went missing, chasing any lead that might explain the abandoned vehicle and the young woman who had simply not arrived where she was going. Decades later, the people who worked the case still spoke of it as the kind of thing that does not fade in a place where everyone knows everyone. Is a death any less deliberate because the man responsible insists it was an accident? Nance was convicted of capital felony murder with an attempted felony as the underlying offense and sentenced to death. Through his years of appeals, he maintained that Julie Heath's death had been an accident, that a blade had lodged in her throat during a struggle, an account his own brother and sister undercut when they testified about what he had confessed to them. His lawyers pressed two further arguments in his final stretch: that he was intellectually disabled and therefore could not lawfully be executed, echoing a question that had haunted other Arkansas cases, and that newer forensic testing might yet clear him. The Arkansas courts rejected the claims, and the state parole board recommended against clemency in November of 2005 by a vote of 6-1. His execution was set for late that November, and it nearly did not proceed on schedule. Shortly before the appointed hour, the Supreme Court justice responsible for reviewing such cases in that part of the country asked for a delay so he could consider 4 separate appeals. For roughly 90 minutes, Nance waited in a holding cell near the death chamber while the nation's highest court deliberated over whether he would live through the night. Then the appeals were denied, all 4 of them, and the execution went forward. He offered no final words, lying still except for a slight movement of his lips as the drugs were administered. He was pronounced dead that night at the Cummins Unit, the last person Arkansas would put to death for nearly 12 years. Members of Julie Heath's family were there to see it. They had waited more than a decade, and in his silence at the end, they read a refusal to account for what he had done, a man who would not, even then, say that he was sorry. To them, the composure he kept on the gurney stood in bleak contrast to the terror they believed he had inflicted, and his passing, however quiet, was a measure of justice long deferred. The grief his crime set loose did not stay contained to that single stretch of highway in 1993. About a year after Julie's death, her mother died by her own hand, a loss her family placed at the same door as the first. It was a part of the case that no verdict or sentence ever formally accounted for. As of today, Eric Randall Nance is deceased, put to death at the age of 45. His execution marked the close of one era of capital punishment in Arkansas, and the long quiet that followed made the crowded, contested April of 2017, and the men whose stories fill this list, all the more staggering when the state finally opened that chamber again. 10 men, 1 prison, and a state that has spent decades arguing over what to do with the people inside its walls. Cummins has held the guilty and the doubted, the executed and the ones the courts never reached, and every name here left the place changed in some way. Thanks for watching. Click here for the next video.